Good morning. We're here today for the in-custody arraignment calendar. Today is Monday, January 19th. Are there any special requests for continuances or requests regarding the order of today's proceedings before we begin?
Good morning, Your Honor. Kelly Costo representing the state. I don't have any requests for continuances. I would ask to take Haley Reynolds' cases fairly early, as I know the victim is present and wanted to address the court.
No objection to that, Your Honor. I have several individuals who have waived. If the court would like notification of that, Haley Reynolds is one.
Thank you. I believe we were speaking over each other. We'll go ahead and handle those in due course.
Excellent. Then we can begin as the state requested with Haley Reynolds.
Thank you. We're going to begin with Brendan Klossel, followed by Summer Ford. And while Mr. Klossel is coming up, just to confirm from the defense in the Washoe County Jail, there is no one, and also from the state, no witnesses who require a Spanish interpreter, correct?
No one that I know, Your Honor. Know of.
Defense?
Only if Jose Caratachia needs Spanish, but to my knowledge, otherwise, no, Your Honor.
Can you please confirm?
He's not present.
Should be here in the next few minutes.
He'll be here in the next few minutes, Judge.
Okay, thank you. We'll go and hold off, and please let us know when he arrives so we can let the interpreter know.
Yes,
Thank you.
ma'am.
Good morning, sir. We're here today for a bail hearing. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, the state is seeking $40,000 bail with no 10% cash alternative, along with pretrial services, supervision. We would ask for a no firearms clause, as well as a no contact order with the victim by court order for 30 days. That is based on several things. Number one, the underlying nature of the offense, the violence of the offense, and the defendant's criminal history. He scored an 8 on the risk assessment, but you can see he got 2 points, or he received 2 points for prior violent criminal convictions. That is based on a 2024 felony conviction for domestic battery by strangulation out of our Second Judicial District Court. The defendant did do mental health court as part of his sentence for that case. He was successful. The case was not dismissed or deferred because of that, but he was successful in completing that court. It looks like in April of 2025. That was a different victim than we see in this current case. He was also convicted of robbery, a separate case. Again, same sentence, meaning he received probation with mental health court as a condition. Again, completed that at the same time. But he's 24 years old, has already suffered those 2 felony convictions, both of those violent. Now we have this new allegations of violent conduct. We were able to speak to the victim. She is not asking for a no contact order. She said she's not afraid of the defendant and believes it was a misunderstanding. She does admit that he has mental health issues that he needs to have addressed. And she did not want to be present here this morning. Even though she's not asking for that no contact order, I believe it's prudent and necessary for her safety, at least for 30 days, to have a cooling off period, along with the bail and those conditions.
Thank you. And state, just to confirm, as the 2 options for no contact orders pursuant to this order, this release order, as well as pursuant to statute, both are court orders. So which one are you requesting?
I'm not asking per statute, Judge. If she wants to get a TPO, she can do that. I was just asking for a general court order for the case.
Thank you. I appreciate that clarification. Defense?
Judge, I'll begin by noting that we saw the Mr. Jose Cacciatore, and he does not need interpreter. I would like to address.
I appreciate you letting us know, and we'll go ahead and Madam Interpreter, at this time, we do not require your services. Thank you for being present here today.
Thank you so much. Bye.
Thank you, defense. Please proceed.
Thank you, Judge. As to Mr. Klossel, we were able to confirm that he has a place to stay, an address, as well as a landline. That would lower his score to a 5. He could stay in a hotel or a weekly in the meantime while he works it out to let that 30 days expire. He has that job at Renini Water Heater Services, and so he would be able to afford that hotel as well, or weekly, as it may be the case. given that he's a 5 rather than an 8, that would be just above that lower score that we rely on in the NPRA. So I'm asking for about $4,000 bondable here. He could put up $400 in cash, and then a requirement that he begin to seek mental health treatment during that same period of time as requested by the state. With that said, Your Honor, I'll rest.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case. Bail will be set in the amount of $5,000 bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by pretrial services and must check in with pretrial services within 1 business day release. I am imposing the condition that he cannot possess any firearms or weapons based off of his criminal history, as well as if this is an alleged crime of violence. I am imposing the condition that beginning immediately, you are to have no contact with Malia Moore. You must not contact and must stay 100 feet away from the victim. You cannot contact or attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. I'm not going to impose it for just 30 days. What I am going to just indicate if state, please let the named victim know that if she wishes to have this resolved, she's more than welcome to file that application to modify the no contact order. But at this time, that will be the order of the court. And we will go ahead and set a 72-hour hearing. And Madam Clerk, when will that be set for?
Set for January 23rd.
Thank you. We'll see you back here in court on that date and time.
All right. Thank you.
Next, we had Summer Ford, followed by Patsy Olvera.
Summer Ford.
Oh, sorry.
You take a seat, Matt.
Yeah, hold on, just sit down for a second. Miss Ford waived, Your Honor.
Are we able to proceed here today as we were unable to proceed yesterday? Just want to make sure. Thank you.
Yes, we can proceed.
Thank you. We're here today for a bail hearing. We'll go ahead and waive her appearance for today's proceeding. I am in receipt of the Nevada pretrial risk assessment, which indicates that she scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, we are seeking $1,000 in bail. We are not seeking any conditions as the defendant is currently under the supervision of the Division of Parole and Probation. She has that pending case or conviction out of the Second Judicial District Court. So for those reasons and her higher NPRA score, we are seeking that $1,000 bail.
Thank
We
you.
won't be objecting to that, Your Honor.
Thank you. Bail will be set in the amount of $1,000 that is bondable with a 10% cash option and based off the facts as presented the Nevada pretrial risk assessment and the factors that's outlined in NRS 178.4853 and NRS 178.498. The court does find that there are no least restrictive means that can be imposed in order to ensure the safety of the community or the appearance of the defendant. I will note the failure to appear history as well as the lack of ties to this community and that she's currently on supervision. I am not imposing any conditions based off the request of the parties, and we will go ahead and set that 72-hour hearing, which will be set, is that for the 23rd? Thank you. That'll be January 23rd at 9:30 a.m. Thank you. Next, we have Patsy Olvera, followed by Haley Reynolds. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 7, which was overridden to a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, based on her original score of 7 and her criminal history, which is mostly misdemeanors, the state's not going to object to releasing her on her own recognizance. Based on the small amount of controlled substances, the state's not seeking any conditions in this case.
Thank you, defense. I'm assuming you have no objection.
Correct.
Thank you, ma'am. I am going to grant your own recognizance release here today. You will be required to appear at your next court hearing, which will be set for February 2nd at 9 a.m. So you must comply with obeying all laws as well as appearing at all court hearings. What I am going to do is I'm not having you be supervised by Reno Justice Court, but I will have you just come to Reno Justice Court to check in tomorrow in order just to ensure that we have your contact information. So you will be, just make sure that you check in within 1 business day release. So that'll be tomorrow. And we will go ahead and set your arraignment as I indicated, which will be for February 2nd at 9 a.m. Thank you.
Thank you.
Haley Reynolds, followed by Justin Temple.
And Judge, Ms. Reynolds waives as well.
Thank you. We're here today for two separate matters. Are you able to proceed with the arraignment for the misdemeanor case?
I am not, Your Honor, only in the sense that I do not have her here present.
Okay. So just want to confirm that you were not able to review the criminal complaint with her?
Correct. I was not even the attorney that spoke with Ms. Reynolds. She refused to speak to Mr. Hold on. Let me step aside, Judge, for the attorney that spoke with Ms. Reynolds.
Your Honor, my apologies. So I was not given a criminal complaint for her this morning, and also she does suffer from severe mental health issues from what I saw. So I was not able to go through anything like that with her today.
Thank you. So are we able to go forward on either of the cases she's here for, that arraignment and bail hearing in RCR 2026-133832, as well as a first appearance bail hearing?
Your Honor, we could go through with the information that we received from her today. She is waiving her appearance for the bail hearing.
So do you have information that she qualifies for a public defender, as we have not appointed, as she refused?
So, Your Honor, I didn't get any information on her finances. I'll be honest about that. But from what I saw, I think she would qualify. I don't see her making any money while she's here in custody.
Thank you. The court will go ahead and grant a public defender in both of these matters. I do find that, given the facts and circumstances, that is appropriate. And so we'll go ahead and appoint the Washoe County Public Defender's Office to represent her on both matters. So just to be clear, as you indicated, you're unable to speak with her. Are you able to waive her appearance for today's proceedings?
Yes, Your Honor.
Thank you. We are going to go ahead then with the bail hearing for both matters. Just for the record, the court is in receipt of the Nevada pretrial risk assessment, which indicates that the defendant scored as a 5 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. As to both cases, the state is going to recommend that she be released on her own recognizance. However, we were only going to make that recommendation if the defendant is placed on pretrial services supervision with conditions of absolutely no alcohol or controlled substances, and testing for both of those. Mr. Barron is here. He is the victim on the domestic battery. He is not seeking a no contact order, so I'm not going to seek that. I will, however, seek the same conditions in both cases, along with a no firearms clause in the domestic battery case. And then with the child endangerment, we'd also be seeking a comply with HSA directives. Unclear how involved they are, but the state certainly believes that she needs to comply with them as part of her conditions.
Thank you. Defense?
We're not going to argue one way or another, Your Honor.
Am I?
Thank you. So, Mr. Barron, the law does afford you an opportunity to be heard. We are just here today on a bail hearing. So whether or not the defendant can be released on her own recognizance, which the parties are all agreeing to, if you are requesting a no contact order, the state's indicating that they're not requesting one on your behalf. So if you have any concerns for your safety, now would be that opportunity for you to speak. If you do wish to speak, I'm just going to ask you first to raise your right hand so I could swear you in. Do you swear or affirm that the testimony that you shall give today shall be subject to the penalty of perjury according to the laws of the state of Nevada, and shall be the truth, the whole truth, and nothing but the truth?
Absolutely.
Thank you. Please state your name and spell your last name for the record.
Edward Barron, Baron.
Thank you. Now's your opportunity to please begin.
Okay. Thank you, Your Honor, for hearing me. Basically, this is kind of there's kind of a loop in this thing here. She's really she's really the victim here. We have been, our biggest problems that we're having is her medical stuff. We're getting her medications and things like that. We are in a big problem with that. And that's why these things are happening. These things have been happening for like the past, within the year, we've had like 3 to 4 episodes, and we've never had this before. And I really think that I got to get her to the doctor to where we can get some blood work done, some things done. It's just not right. I mean, this is for anxiety, and that bottle is that.
Sir, I'm going to have you lower that bottle, as everything's being recorded
Oh,
and live streamed on the internet. So I don't want her personal information on
God,
the internet.
apologize for that. Anyways, the deputy with this charge for the domestic, I have it in my phone from the deputy that was dismissed. So, and it's in from his text message to me directly, because we were trying to get we knew all this was all medically related. This has nothing to do with her being a criminal, and this is all medical. She has bipolar, hysteria, and some things, some other things, and we're really trying to fight through this, and we're really having a difficult time with medical.
Thank you. I appreciate that information. State, do you have any questions for Mr. Barron?
I do not, Your Honor.
Defense?
None.
Thank you. So, sir, I am going to release Ms. Reynolds here today. I appreciate your information. I would just encourage you to speak with the district attorney's office. As I indicated, we are just here today for the bail hearing. So in RCR 2026-133-832, Ms. Reynolds will be released on her own recognizance. I will require that she be supervised by pretrial services. I'll note that this is a misdemeanor case, however, as I will be assessing her pretrial services in the other matter. I do find that is appropriate. I am requiring that the defendant cannot use any controlled substances or alcohol unless she has a valid prescription and be subjected to random drug and alcohol testing. I am imposing the condition that she cannot possess any firearms or weapons, as this is an alleged crime of violence. I am, that will be the order in the court for that case. We will go ahead and set a PSS, and that will be set for February 5th. And Madam Clerk, what a time?
You do 9:30. 9 o'clock.
Thank you. That'll be the order of the court. We will also set an arraignment, which will be set for February 2nd at 9 a.m. And then with respect to RPC 2026-065381, the court does find that there are least restrictive means that can be imposed. So the defendant will be released on her own recognizance. She will be required to be supervised by pretrial services and must check in with pretrial services within 1 business day of release. I am imposing the condition that she cannot use any controlled substances or alcohol unless she has a valid prescription. I do find that there's a sufficient nexus in both of these matters based off of the allegations. Additionally, I am imposing the condition that she is required to comply with Human Services Agency, HSA. That will be the order of the court. And in that case, we will also set that arraignment, which will be set for February 2nd at 9 a.m.
Do you want to just?
Are we able to do that? Thank you. We'll go ahead and make that change. I don't know if the parties could hear. I'm going to just set her requirements to appear in Reno Justice Court on February 5th for the arraignments as well as the pre-sentence screening. So that'll be February 5th. Thank you. Thank you, and sir, and that concludes this hearing.
Thank you.
Next, we have Justin Temple, followed by James Valerie. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has not been appointed to represent you. Do you wish for this court to determine if you qualify for their services?
Yeah.
Thank you. Sorry, there's a lot of background noise, so I couldn't hear you. I saw you saying yes. Is that correct?
Yes, Your Honor.
Thank you. Assuming that you were to remain in custody, approximately how much money are you able to make per week, if any?
0.
Thank you. I do find that you qualify for the services of the public defender, so the Washoe County Public Defender's Office will be appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 5 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, even with that moderate score of 5, state believes bail is appropriate based on the facts of the case. We're seeking $10,000 with pretrial services with a no alcohol clause and daily testing for that substance, along with a no firearms or weapons clause. Again, that's based on the facts of the case. The defendant's lack of compliance with law enforcement, his possession of the hatchet during this incident. Clearly, there's some domestic issues going on as well at the same time. His criminal history, I show 1 prior battery conviction back in 2007. But again, based on the evidence outlined in the probable cause declaration, the state does believe some bail is appropriate and seeking that $10,000. Again, with those conditions, in addition, we would ask for a no contact order with Michaela Temple, who is the victim of the destruction of property.
Thank you. Defense?
Judge, the MPRA is the best tool we have. It says he rates as a 5, but we were able to confirm his residence as well as a job and a cell phone number. That lowers him down to a 3 at best, maybe even a 2. Given that's our score for rating people, whether or not they're going to commit violence or appear in court, I'm going to ask for an OR release in this case. If the state did not yet ask for a no contact order, or if they did, I missed it, I apologize, but he can stay at a hotel or a weekly as well, and he was able to confirm that. He can afford that weekly because of the job that he has. I think the conditions the state requested are appropriate, and we would ask for those to be imposed as well as part of his OR release.
Thank you. I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community, as the state has not met its burden by proving by clear and convincing evidence that a detention order is necessary. So the defendant will be granted an unrecognizance release. I will require that he be supervised by pretrial services. So you must check in with pretrial services within 1 business day of release. I am ordering that you cannot possess any firearms or weapons, as this is an alleged crime of violence. You are required to not use any controlled substances or alcohol unless you have a valid prescription. Be subjected to daily alcohol testing. It'll be for alcohol only based off of the information provided. I do find that there's a sufficient nexus and that is necessary as the least restrictive means in order to ensure the safety of the community and the named victims in this case. You are also ordered at this time to have no contact with it is not a minor child. Thank you. I just wanted to confirm that. So with Michaela Temple, then that is beginning immediately. So you cannot contact them, stay 100 feet away from the named victim, cannot contact or attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. We will set that arraignment, which is set for February 2nd at 9 a.m. So you are required to appear in Reno Justice Court on that date and time, as well as comply with these conditions, or else a bench warrant will be issued for your arrest. Thank you. Next, we have James Valerie, followed by Justin Walker.
Your Honor, I'm being informed that he refused.
Are we able to proceed, or do you need a continuance?
Let's proceed.
So you're able to waive his appearance for today's proceeding?
Yes.
Thank you. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent the defendant. I am in receipt of the Nevada pretrial risk assessment, which is for the record, he scores as a 10 or a higher risk utilizing that tool. Based on the request of the defense, we'll go ahead and waive his appearance for today's proceeding. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, state is seeking $5,000 along with pretrial services and testing for controlled substances, as well as a no contact with the Peppermill Casino. We are asking for that bail and those conditions based on his high risk assessment score of a 10. This is a category D, I believe, is the PCS third. He does have 2 prior felony convictions, one in 2015 and one back in 2006. Both of those for possession of a controlled substance. He's got another felony grand larceny conviction out of our first judicial district court in 2011. His most recent history shows noncompliance. In 2025, he has a citation pending out of Reno Municipal Court for petty larceny. That is that warrant that he was that showed up when they went to arrest him on this case. He failed to appear at his arraignment in that case, and a bench warrant had to be issued back in March of 2025. He's got convictions in 2022 for paraphernalia and trespassing and sort of similar convictions throughout the years. So based on his first conviction was back in 1999 for theft and domestic battery in 2002. So very lengthy criminal history. So based on all of that, his high risk assessment and his non-compliance issues, the state believes that that bail and those conditions are appropriate.
Thank you. Would you have any objection to a bail or an unrecognizance release through direct transport to an appropriate treatment facility?
No, Your Honor.
Thank you, defense.
We're not objecting, Your Honor.
Thank you. Based on facts as presented in the Nevada pretrial risk assessment, the factors as outlined in NRS 178.4853 and NRS 178.498. 178.498. I do find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community as well as the appearance of the defendant. Bail will be set in the amount of $5,000 bondable with a 10% cash option based off those non-compliance concerns, the higher Nevada pretrial risk assessment and the failure to appear. In this case, the court will require that the defendant be supervised by pretrial services. So if he's able to post that bail, and I can't recall if I said it, just for the record, it'll be $5,000 bondable with a 10% cash option in case I did not. If the defendant is able to post that, he will be required to be supervised by pretrial services and must check in within 1 business day of release. Cannot use any controlled substances or alcohol unless he has a valid prescription, be subjected to random drug and alcohol testing. I do find that there is a sufficient nexus based off the allegations. Additionally, this order will read bail or an unrecognizance release through direct transport to an appropriate treatment facility. I do find that that would be a least restrictive means that can be imposed in order to ensure the safety of the community. That will be the order of the court, and we'll go ahead and set a 72-hour hearing, which will be set for January 26th at 9:30 a.m. Thank you. Justin Walker, followed by Donald Dean. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, the state is seeking $10,000 with no 10% cash alternative based on the category B robbery charge. The state, along with conditions of pretrial services, testing for controlled substances, no weapons, and no contact with the Dollar Tree. State believes that that bail and those conditions are necessary based on his high risk assessment score of 11. Again, you can see this defendant was arrested for a failure to appear bench warrant when he was arrested on this offense. I don't know what crime that is related to. It's not on his criminal history, but it does show that it is out of Sparks Municipal Court and it is listed as a failure to appear bench warrant. His criminal history is 2023, he was arrested for possession of a controlled substance out of the Reno Justice Court. That case went through the process. He failed to appear 2 different times during the pendency of that case while he was on pretrial supervision. It ended up being dismissed based on the Good Samaritan NRS eventually, but that doesn't wipe out that he failed to appear 2 times during the pendency of that case. He was also arrested for robbery out of California in 2023, along with a conspiracy to commit the robbery. There's no disposition, but it does show a failure to appear arrest associated to that offense. And then finally, in 2018, he has a misdemeanor conviction for possession of drugs for not for interstate commerce. That was out of Hawthorne, Nevada. So based on that history, as well as, again, the underlying facts of this case and the high MPRA, the state does believe a bail is necessary to assure that he shows up for court, as well as does not commit further violent crimes. So we're asking for that $10,000 and the previously asked for conditions.
Thank you, defense.
Judge, we're asking that you make it $8,000, but bondable. That way he has a chance to get out and afford the bail. That also puts some of his money in the game as well. Conditions, I think, can be fashioned such that he stay away from the location, as well as any of the individuals involved. He does have a place to stay at his aunt's house. We were unable to confirm that. However, he assures us that he could stay there and he has stayed there in the past. He told us he does DoorDash, but that too was something we were unable to confirm. If he could put up that money, Your Honor, it would have him a chance to be out with the least restrictive means possible.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. The court will note the compliance concerns that discuss the lack of ties to this community, as well as the history involving failure to appear. And bail will be set, and that amount is discussed of $8,000 bondable with no 10% cash option. I am imposing the condition that if Mr. Walker is able to post that bail amount, sir, you will be required to be supervised by pretrial services, so you must check in with pretrial services within 1 business day of release. I am imposing the condition that you cannot use any controlled substances or alcohol unless you have a valid prescription, be subjected to random drug and alcohol testing. I do find that there's a sufficient excess based off the allegations to require for that to occur. Additionally, I am imposing the condition that you must stay 100 feet away from the Dollar Tree location at 2424 Audi Boulevard. That will be the order of the court, and we will set a 72-hour hearing, which will be set for January 26th at 9:30 a.m. Thank you.
Thank you.
I don't believe that I did. My apologies. Thank you for catching that. I am imposing the condition that you cannot possess any firearms or weapons, as this is an alleged crime of violence. Thank you. Next, we have Donald Dean, followed by Kenneth Fry. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 15 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, the state is seeking $15,000 for Mr. Dean. That is based on his conduct in this case, coupled with his very high risk assessment of 15. As you can see from pretrial services paperwork, he has numerous pending cases. Both of those from this year are trespassings out of Reno Municipal Court. He also has a conviction in 2025 for domestic battery. That is also out of Reno Municipal Court. He is currently under a suspended sentence for that case, which includes obey all laws. He was sentenced on that on September of last year. He has a suspended sentence for 2 years. He had a probation violation late 2025 in December, but they did not revoke his probation. He also has convictions for drug paraphernalia in 2024, intoxicated pedestrian on a roadway in 2024. He has more trespassing convictions in 2022. He does have a felony conviction for an attempted robbery in 2020. And then he's got felony convictions for theft in 2019, another one in 2013, a felony conviction for burglary in 2005. He's got history that dates all the way back to the 1990s. So lengthy criminal history revolving around theft-related offenses. That, coupled with his continued use of controlled substances, makes him a danger to our community. So we do believe that the $15,000 with pretrial services testing is mandatory in order to make sure that he is no longer a danger to our community. We'd also ask for a no contact with the vagabond in property.
Thank you, defense.
We're going to submit it, Your Honor.
Thank you. Based on the facts presented in Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the NPRA's discussed the failure to appears, the history of similar offenses and the history of non-compliance. Bail will be set in the amount of $15,000 that will be bondable with a 10% cash option. So if you're able to post that bail amount, you will be required to be supervised by pretrial services and must check in within 1 business day of release. You are ordered to not use any controlled substances or alcohol unless you have a valid prescription to be subjected to random drug and alcohol testing. I do find that there's a sufficient access based off the allegations, and I am imposing that you cannot have any contact with the vagabond inn located at 3131 South Virginia Street, so you must stay 100 feet away from that location. We will go ahead and set your next hearing, which will be a 72-hour hearing on January 26th at 9:30 a.m. Thank you. Next, we have Kenneth Fry, followed by Cody Kaphan. Good morning, sir. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 12 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Even though he scores higher on the risk assessment based on the facts of the case, the state's not going to object to releasing him on his own recognizance when we aren't seeking any conditions.
Thank you. Defense, I'm assuming no objection.
No objections. I want to make sure that I imagine stay away from Circus, given pickup. Okay. No objection.
The state is not requesting any conditions, so I'll just make sure it's clear that the defendant is not permitted to be at any location that will remain. I don't have information that I need to state otherwise.
Perhaps
Mr. Fry. And so I am granting an own recognizance release here today. So sir, you will be released. You are required to just check in with Reno Justice Court within 1 business day of release. Just make sure it's clear if you're not being supervised by Reno Justice Court, but I am requiring that you come to Reno Justice Court tomorrow. You are also going to be required to appear for your next court date, which will be set for February 2nd at 9 a.m. And so you must obey all laws and come to all your court appearances. And so we will see you back here in court on those next dates. Thank you.
Thank you, ma'am.
Next, we have Cody Kaplan, followed by Sonoria Loya.
Sorry, Judge.
Good morning, sir. We're here today for first appearance bail hearing. My apologies. How do you say your last name?
Capan?
Thank you. We're here today, as I discussed, for those issues. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 11 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, in this case, we are seeking bail in the amount of $5,000. We're not seeking any conditions. We do believe that bail is necessary based on his continued criminal activity. You can see he scores higher on the risk assessment at 11. And as pretrial services let the court know, he does have 4 pending cases in Reno Municipal Court. Those are for trusts. Look at 3 trespassing cases pending, 1 petty larceny case pending where he did fail to appear. The court did not issue a bench warrant in that case. They basically combined all of those with an arraignment date of January 27th, 2026. In addition to those, all pending from 2025. He has also felony convictions in 2025 for possession of a stolen motor vehicle out of the 4th Judicial District Court and possession of a controlled substance out of the 4th Judicial District Court. It looks like he's still on probation for those cases. I didn't see any kind of hold for him. And obviously that's not our jurisdiction, so I can't check, but I don't see a hold for him out of those yet. In addition to those convictions, he also has convictions for domestic battery in 2015, 2 different cases of domestic battery in 2015, both of those out of Elko. And then he has some 2 different DUIs, both out of Elko and New River Township, and then a petty larceny back in 2009. So the defendant continues to accumulate criminal history. It sounds like he continues to show up at Circus after being formally trespassed several times, and that's evident in his recent cites out of Reno Municipal Court. So all of that combined, we believe that bail is necessary in the amount of $5,000. Again, not seeking any conditions, and I'll submit it.
Thank you, defense.
Judge, we only ask that you make that number bondable.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community as well as the appearance of the defendant. I will note the significant pending criminal issues as well as the lack of ties to this community and the likelihood of conviction. Bail will be set in the amount of $5,000 bondable with a 10% cash option. And sir, if you are able to post that bail amount, I will require that you just check in at Reno Justice Court within 24 hours of release. And we will go ahead and set your 72-hour hearing, which will be set for January 26th at 9:30 a.m. Thank you.
About $500 just on this case.
Senoria Woya, followed by Christopher Northcutt.
Judge, if I could begin on something about this case, although he's indicated he would retain private counsel, he asked for us to have him be represented today.
Thank you. I approved it and I shouldn't have it that based off of that. So I do appreciate that. So sir, do you have any information defense counsel that qualifies for the services of a public defender?
No, but I would of course agree for him to answer those questions.
Thank you. So sir, assuming that you were to remain in custody, are you able to make any amount of money?
Yes, I'm working right now.
Are you able to make that income while you are in custody?
No, I'm not, Your Honor.
Thank you. I do find that you qualify for the services of the public defender. So just for the record, the public defender's office will be appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
I'm sorry, Judge, could I have one more moment, please? We weren't able to get a hold of your wife. Ready to proceed.
Thank you, State.
Your Honor, we are seeking $5,000 in bail for this defendant. It says he scores a 6 on the risk assessment. He has a significant criminal history. The state's concerned is not only that criminal history, but also his lack of ties to our community. It appears that he was residing at the GSR and had not been here in town for very long. He should not be allowed to go back to the GSR based on the conditions that the state is going to ask for as part of that bail. Would be pretrial services supervision along with a no contact order with the GSR. His entire criminal history is out of California. His last arrest was in 2024 for giving a false identification. However, prior to that, he had in 2012, he was convicted of DUI with a prior making it a felony, along with a hit and run injury. It looks like he did some significant prison time related to that offense. His next arrest after that is 2018. And then we have the 2024 contact. Prior to that, he has a felony conviction for prohibited person in possession of a firearm, prohibited person in possession of ammunition, shooting at an unoccupied dwelling, and shooting at a inhabited dwelling out of California. Again, he received a prison sentence in that case. That was back in 1999. And then he's got other prior misdemeanor convictions for domestic battery, using or being under the influence of a controlled substance. And then way back in 1995 is his first conviction for hit and run property out of California. So significant criminal history over a lengthy period of time, all out of a different state. So we do believe some amount of bail is appropriate, $5,000, again, with pretrial services supervision and no contact with the GSR.
Thank you, defense.
Judge, we tried calling his wife twice. We weren't able to reach her. I understand that he's got a residence in California. However, he does have work as a plumber and electrician. And I guess my concern is that given the value of that job, I understand he can't stay at the GSR. I know he needs a place to stay.
Final place.
But he can come back and take care of those court dates as the court requires if he's allowed to work and have those conditions in place. Because of the nature of those two jobs, he could afford GPS monitoring if the court were to order it. And so I'm going to ask for some kind of combination of conditions as fashioned by the court to make sure that he returns and deals with his issues. He scores a 6 on the NPRA and does not have a history of failing to appear or violence per the NPRA tool. So I'll rest it on that.
Thank you. Based on the facts presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note that given the level of violence as alleged to be used in this case, that the threat of harm to the safety of the community, although the NPRA does not discuss prior crimes of violence, I'll note the significant remote criminal history involving crimes of violence, as well as lack of ties to this community and the likelihood of conviction in this case. Based on that, bail will be set an amount of $3,000 that'll be bondable with a 10% cash option if the defendant is able to post that bail amount. Sir, you will be required to be supervised by pretrial services, so you must check in with them within 1 business day of release, and you cannot have any contact with Grand Sierra Resorts. You must stay 100 feet away from that location. We'll go ahead and set your 72-hour hearing, which will be set for January 26th at 9:30 a.m. Thank you.
Thank you. All right.
Christopher Northcutt, followed by Jose Cartechea.
Mr. Northcutt waived, Your Honor.
Thank you. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent him. I will go ahead and waive his appearance for today's proceeding. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored a 15 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. Your Honor, the state is seeking $50,000, 50, with no 10% cash alternative based on the attempted robbery of an elder person charge, category B, as well as the other charges. Clearly, this case or the probable cause declaration outlines use of violence against the elderly victim, which happens to be his mother. He scores high on the risk assessment at a 15. You can see he got 2 points maximum number for prior failures to appear. His criminal history is a misdemeanor conviction for possession of drug paraphernalia out of Sparks Justice Court in 2025, a battery conviction in 2025 with a 90 days suspended sentence and obey all laws clause. He looks like he's still under that suspended sentence from last year. He has a 2024 case for basically being in the park after hours. I tell the court that because they tried to help treat Mr. Northcutt with a community court sort of type sentence with treatment conditions and lots of assistance. Unfortunately, he was revoked on that sentence in May of 2025. He failed to appear post-sentence. He didn't comply with those conditions. In 2022, he was convicted of domestic battery. That was against the same victim that we see here. That was out of Reno Municipal Court. 2017, another battery conviction, this time out of Reno Justice Court. Looks like this time he did a specialty court and was actually successful. Unfortunately, we know that he had new convictions and contacts with the law, including violence after that case ended. And then he has a long criminal history, almost all revolving around substance abuse, dating back to the early 1990s. He has suffered a felony conviction for possession of stolen property in that time as well, but other batteries, assaults, DUIs. So the defendant does pose a risk to our community, specifically to his mother, the victim in this case. So the state does believe a higher bail is appropriate of $50,000. We're asking for pretrial services with a no contact order per court order, meaning as part of the case with the victim and her residence, as well as a no firearms or weapons clause, as well as a testing for controlled substances based on what's evident from the probable cause that he continues to suffer from using controlled substances. We did try to reach out to the victim. We left her a message. Unfortunately, we had not heard back from her prior to court today, but she was notified of the bail hearing.
Thank you.
Nothing, Your
Defense?
Honor. Nothing.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the prior history of violence as well as in this court's review and odyssey of the public record regarding his most recent criminal matter in 2024 of what I'm counting as at least 3 separate pretrial violation reports, as well as issues regarding to failure to appear. With that in mind, bail will be set in the amount of $40,000. That'll be bondable with no 10% cash option. I am requiring that the defendant, if he's able to post that bail amount, to be required to be supervised by pretrial services. I am also imposing the condition that he cannot possess any firearms or weapons, as this is an alleged crime of violence. And state, I apologize if you indicated it. I did not hear. Are you requesting a no contact order?
Yes, Your Honor.
I don't have a last name for the named victim.
I do, Your Honor. It's Odone. It's O comma or apostrophe, sorry, DOAN.
And then the first is CELIA.
Yes.
Thank you. I am imposing that no contact order. I do find that that is necessary in order to ensure the safety of the named victim in this case. Just to make sure that is clear for the record, that does begin immediately. So the defendants to have no contact must stay 100 feet away from the victim, cannot contact or attempt to contact her in any way, including in person, phone, texting, electronic means, or through social media, either directly or through an agent. That means someone working on its behalf. That will be the order of the court, and we will go ahead and set a 72-hour hearing. And that will be set for January 26th at 9:30 a.m. Thank you. Jose Cartachea, followed by Linda Tedder.
Judge, if I might have a brief moment. You
You
read
may.
this? You understand? We're ready to proceed, Judge. Thank you.
Thank you. Good morning. We're here today for a bail hearing and an arraignment. And sir, how do you say your last name?
Carpacheo.
Thank you. My apologies if I mispronounced that. I am in receipt of the Nevada pretrial risk assessment, which for the record indicates that you scored as an 11 or a higher risk utilizing that tool. Defense counsel, are we able to begin with the arraignment?
We are, Your Honor. His name is spelled correctly at line 7, familiar with its content, so he'd waive a formal reading. He's going to enter not guilty to that charge, unless, of course, the state is looking for a no jail complaint here.
Thank you. We'll go ahead and turn to the bail hearing. State.
Your Honor, we are going to ask you to leave the $5,000 that was placed on the arrest warrant by the court in place. We're not seeking any conditions other than to not have contact with the El Dorado Casino. You can see he scores high on the risk assessment at 11. Probably most importantly, the defendant currently has a case pending in the Second Judicial District Court, which he is on diversion for. He has had probation, or he does have a violation of his probation in that case, which is currently being taken care of in the Second Judicial District Court. So regardless of what happens here, he will remain in custody on that case until they figure out how to proceed. He has a pretty, not pretty, but a very lengthy criminal history dating back to the mid-2000s with numerous felony convictions. Like I stated, he is on probation, and I believe he was on probation when this new case happened.
Thank you, defense.
Judge, looks like he's got a warrant from another location. This is an ad book charge as far as I can tell. Client tells us he can go to the CARES campus and he can pick up work as a warehouse worker, which he has done on multiple occasions. He's asking for an OR here. We think that might be appropriate given the situation. Give him a chance to work and pay back what he might owe.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note that higher Nevada pretrial risk assessment, the likelihood of conviction and the lack of ties to this community. And so bail will be set in the amount of $5,000 that is bondable with a 10% cash option. Sir, if you're able to post that bail amount, you will be required to be supervised by pretrial services. And I apologize, the state didn't request for that. So I'm not correct, state, you did not request that because he's supervised. Thank you. So I'm not imposing that condition, but I am imposing the condition that you cannot and must stay away. So cannot contact any of the rogue casinos, which does include El Dorado. So you must stay 100 feet away from those locations. Defense counsel, are we setting a mandatory status conference or is he invoking his right to a speedy preliminary hearing?
I'm going to ask for a mandatory status conference in this matter, Your Honor. Thank you.
Thank you. And Madam Clerk, what will that date be?
February 3rd at 1:30.
Thank you. We'll see you back here in court on that date and time.
You get a prelim in two weeks now.
Linda Tedder, followed by Shelley Colonger. Good morning. We're here today for an arraignment and a bail hearing. Just for the record, probable cause has been found. The court has received the Nevada pretrial risk assessment, which indicates that defendant scored as a 12 or a higher risk utilizing that tool. We'll go ahead and turn to that arraignment. And defense counsel, are we able to proceed with the arraignment today?
I do not have any criminal complaint for the arraignment, Your Honor.
Thank you. Can I confirm at the Washoe County Jail, I believe that criminal complaint was provided. Do you need us to resend it?
And they resend it.
Please.
Thank you. We'll go ahead and resend it. So, ma'am, I'm just going to trail your case. If you want to sit back down, I'm going to call the next case and then I'll come back to you. Thank you. Shelley Collinger.
She waived, Your Honor.
Thank you. We're here today for a first appearance for a fugitive matter. Probable cause has been found. We will go ahead and set that 72-hour hearing, which will be set for January 26th at 9:30 a.m. Thank you. Next, we have Chauncey Jackson.
Mr. Jackson waived as well, Your Honor.
Thank you. We're here today for first appearance. This is for a fugitive matter. Probable cause has been found, and we will go ahead and set that 72-hour hearing, which will be set for January 26th at 9:30 a.m. Thank you. And we will just be in recess. We don't need to log off or anything until defense counsel, you let me know that we're ready to proceed on the other matter.
We'll be very brief. Mr. Murillo is already working with her.
I can see that. Thank you so much for that.
Oh, thank you. Judge, could we have a brief continuance until tomorrow? Ms. Tedder is not able to follow through this morning.
Thank you. Steve, do you have any objection?
No, Your Honor.
Thank you. We'll go ahead and continue this matter until tomorrow at 9:30 a.m. I do find that there's good cause on the basis as discussed. Thank you.
Thank you.
Thank you. And I believe that concludes today's calendar. Just want to confirm before we log off.
That's everybody.
I believe that's the calendar, Your Honor.
Yes.
Thank you, everyone. Have a wonderful rest of your day.
Thank you. You too.